Suppose you have taken a loan from a bank and for some reason you have defaulted. Now the bank calls you and threatens you that it will take legal action against you. Now, can a bank get you arrested for non-repayment of the loan? The truth will surprise you. So, under Indian law, you cannot be jailed just for not paying the home loan or your personal loan or any credit card bill or of any other loan of similar nature. Let's see why the court is liberal with you in the first instance in such a situation and not, issuing an arrest warrant and instead giving you an opportunity to establish your case. Now, this liberal approach of the court is fundamentally derived from ICCPR, which is International Covenant on Civil and Political Rights, read with Constitution of India. Why? Because under Article 11 of ICCPR, it says that no one shall be imprisoned merely on the ground of inability to fulfill a contractual obligation, which is incorporated in Article 21 of the Constitution, that we all know, which is very famous, that our personal liberty cannot be curtailed that easily. So this observation was made in the classic case of Supreme Court, which is Jolly George Verghese versus the Bank of Cochin. This is the case of 1980, where Justice Krishna Iyer took this observation and compared this international covenant, the right mentioned under this article, and which India has ratified to it, and which is reflected in Article 21 of the Constitution. So here, keeping in view the rights under those international covenant and the Constitution of India, Justice Iyer actually took note of the case of Jolly George Verghese, who is a defaulter. So in this case, what had happened from the beginning is that this Bank of Cochin had initiated a legal action before the lower court against the defaulter Jolly. So now the court had, without giving an opportunity to Jolly for an hearing to present his case, his genuine case, why he cannot repay the loan, had issued an arrest warrant. And that is why the defaulter, had immediately came to Supreme Court to challenge that judgment, that decree of arrest. So when Jolly came to Supreme Court challenging the decree order of arrest, the Supreme Court, wherein Justice Iyer had actually observed the genuine condition of Jolly, where although he had the intention to pay, he was not able to pay it, because whatever money he had spent it in the medical treatment for the he was suffering from cancer and he spent it there. And then, finding that this is the genuine case where Jolly should have given the opportunity to explain his case before the arrest warrant would have been issued by the lower court, the Supreme Court had sent it back to the lower court to re-examine the case based on the facts noted in this scenario by the Supreme Court itself. So with this, we have actually understood the case or situation where a person cannot be arrested. Now let's understand the exception to it when a person would be arrested. From the situation where it says cannot pay and will not pay. What does it mean by cannot pay? That, for example, in this situation, he was actually, in genuineness, he was not able to pay, but he had the intent to pay. He had no cash, no asset, that's why he was not able to pay. However, in a situation where you will not pay, in this case, what the inference would be that you are deliberately not paying. You have all the means to pay, you have cash, you have all the assets, you are traveling here and there, you are doing all the shopping, but you are not repaying the loan. So in that case, it won't be called as a genuine case and you will get arrested and an arrest warrant will be issued against you. So this is how our Indian law differentiates between a genuine case and a willful default case. So in the case of genuine default, you will not be arrested. In the case of willful default or deliberate default, you will get arrested. So this is all I wanted to share.